Hi, my name is Lorenzo Azar Banks, here on behalf of Minority Report Law Office here in Oklahoma City. And today I wanted to do another video response to a question that we had posed to us in light of some of the recent events in the state of Florida. And the question was, does the Stand Your Ground law protect people like George Zimmerman in the shooting of Trayvon Martin? The answer is no. The statute, as written, would not protect people similarly situated as George Zimmerman in the shooting of Trayvon Martin. And this may be very surprising considering what we've heard in the media and what we've heard from friends and family, but the statute as written would not protect people in these situations. So let's understand the statute a little bit better so we can understand the answer. Now, the statute in Florida for Stand Your Ground and the statute in Oklahoma for Stand Your Ground are word for word the same. So I'm giving you an Oklahoma perspective, but the perspective is based off of a statute that is identical to the one that is in Florida. And what the Stand Your Ground law says is essentially this. If you get into an altercation with an individual outside the parameters of your home, you have a right to stand your ground and defend yourself. You have no duty to retreat, and you will be absolved of all civil and criminal liability, and quite possibly escape prosecution altogether if you meet three certain requirements. And you have to meet these requirements conjunctively, which means they have to happen all at the same time. Number one, you cannot be doing anything unlawful at the time you stood your ground. So you can't be doing anything that was illegal at the time you decided to stand your ground. Number two, you have to be in a place that you actually had the right to be in when you were attacked. You actually had to have a right to be in that place before you can claim stand your ground as a defense. And number three, you have to meet force with force, and possibly you can use deadly force. Meeting force with force means it's proportional. You can only use as much force as is necessary to escape the threat. You can use deadly force, but only under certain conditions. It has to be reasonable, considering all the circumstances. Would a reasonable person fear that they were in serious danger of serious bodily injury or imminent death? And law enforcement and courts will look at all of the circumstances surrounding the altercation to determine whether or not it was reasonable. It has nothing to do with the subjective intent or the subjective standpoint of the individual. It has to do with an objective standard, what a reasonable person in society would feel. Were they in fact at a place where they needed to defend themselves with deadly force? And if you have all three of these factors together, you may in fact stand your ground as a defense to a particular homicide. Now, for every rule there's an exception. The exception to this rule is the initial aggressor exception. It is well-founded and well-established law in the state of Oklahoma that you may not raise the stand your ground defense if you were the initial aggressor, if you started it, if you were the person who exacerbated the altercation. And right now I am flashing several cases at the bottom of the screen with their holdings, just so you'll get an idea that this has been around in Oklahoma for quite some time. The stand your ground defense is not available to you if you in fact were the initial aggressor. So this is the stand your ground defense, and this is the important exception to the rule that we have to know when we're dealing with people in society. So some things we want to take away from this video. We hear from friends and in the media that this particular law gives people a wide latitude of when they can use deadly force. But that's not true, is it? No, the statute is actually very explicit as to when you can use deadly force, only when it's reasonable, under all the circumstances, that a reasonable person would believe that they were in fact in harm's way of serious bodily injury or imminent death. So that statement, that contention is slightly misleading. There's also the contention that, well, this particular statute causes profiling. And I can't speak for that or against it, but assuming arguendo that it does, removing this statute is not going to stop profiling. And as bad as profiling is very legal in the United States for people who are regular citizens. You can profile all you want. What is illegal is when you start an altercation based off of that profile and then murder someone and try to hide yourself behind the shield of stand your ground. It doesn't work like that, which is why it is well established in case law that initial aggressor is the exception to the stand your ground defense. And lastly, is the law itself bad? I would say no. What you're seeing in Florida is not necessarily a bad statute. You're seeing evidence of potentially bad police work. Mr. Zimmerman shouldn't be afforded the protections of stand your ground because not only was his force against Trayvon seemingly disproportionate, it also didn't seem reasonable considering that Trayvon was 17 carrying a pack of Skittles and an iced tea. It just doesn't seem reasonable under the circumstances to fear for your life. But even if it did seem reasonable, from the evidence of the 911 tapes, it seems clear that Mr. Zimmerman was in fact the initial aggressor, and therefore, based off case law, should not be afforded the protections of stand your ground. Hopefully, on April 10th of this year, a grand jury will indict Mr. Zimmerman for what I believe, in my professional opinion, to be a crime. But we'll see. Once again, my name is Lorenzo Azar Banks, here on behalf of Minority Report Law Office. You can reach us at minorityreportlaw.com, or you can catch us on our Facebook page at facebook.com/MR Law Office. I hope this was informative. Please say a prayer for Trayvon Martin's family tonight, and we'll see you next time.